Okay, Josh here with USI-Tech Legal Claims. This is our third video. Again, my name is Josh. I'm the host here, and for those that don't know, my background is I'm an executive and an attorney. I practice in my own law firm. If you want more details about my background, I go into that more extensively in the first video and a little bit in the second video. But moving straight on into this, I've got some breaking news, some important news about USI-Tech that I think that the community will want to know. So first things first, you'll remember the hopeful communications, what I refer to as the hopeful communications, the rumor mill, the USI-Tech rumor mill that's out there that's churning, providing information, hopeful information about USI-Tech's return or various different similar things. Okay. Here we have the what I refer to as the hopeful communications. I covered this document extensively and what it says in my last video, the second video that we did. I'm not going to rehash it here, but basically this is just an example of the USI-Tech churning rumor mill. People and things out there trying to put out hope in the sense of cause people to continue to be hopeful, to look for USI-Tech to return to Canada and to the United States, its operations to reopen, that supposedly USI-Tech, as I covered in these hopeful communications, is in the clear because the Texas Securities Board found that it does not have sufficient evidence and that the Texas Securities Board is being forced to drop its case and the issues against USI-Tech. That's right here. So these are communications that have been floating around and things have been, represented by whoever is out there representing those things with regard to USI-Tech and the Texas Security Board. And in a larger sense, USI-Tech being able to come back into the United States, start operating again, and business to go on as usual in the U.S. and Canada like nothing ever happened. So I have breaking news about that, which I will go into detail here in just a few moments, but it involves just going directly to the horse's mouth. I have now had a conversation with the Texas Securities Board, individuals at the Texas Securities Board, about this. Rumor is rumor, conjecture is conjecture. Why not get information straight from the source and get the knowledge that we, if it's possible to get knowledge. Get into that here in a second. I have to lay some foundation first before I get there. So, as part of this whole kind of universe of confusion and the rumor mill and everything that's going on, there are a few points of known information. We have what is showing up in people's back offices, which at times seems to be changing or conflicting or different, if not conflicting. For example, and I've got three things to show you here, three primary things to show you. So one of the things that's shown up recently, for those of you that haven't seen this, it's showing up in a lot of people's back offices, is this message that is described as the explanation of the statement regarding USA and Canada. At the very top of that image there you see statement USA, Canada. When for a lot of people, if in the US and in Canada, when they log into their back office, immediately at the top, there is a link that says Statement USA Canada, and you click on that link and then you get this message. And it provides this explanation. And it goes into, like many of the other communications that have come out recently, the notice of extraordinary termination, notice of summary and extraordinary termination of all U.S. and Canadian accounts and contracts with promoters. Kind of like that communication, this communication also kind of says, hey, all of you all did things wrong, and so now we're having to clean up the mess. You can read this message for yourself, but in short what it says is we're having to do an investigation into double account registrations, unlawful payouts related to that. We will prosecute these abuses to the fullest extent of the law. Until these investigations are complete, we are barred from making any payments to prevent additional abuses. Presumably, payments, what they're referring to is paying out any requested withdrawals from daily available balances in any and all accounts for people that are in the U.S. or in Canada. I'd be interested to know is the if people do that kind of thing in the United States, are people similar in other countries? Are there people in other countries that potentially have had double account registrations? Why is the rest of the world not shut down? And why is there not a worldwide investigation going on with regard to double account registrations and whatnot? I would be willing to bet a whole heck of a lot of money that there are at least some double account registrations and things outside the U.S., just as there are inside the U.S. And if that were the case, and I'm sure it is, because people are people, and there are good people and bad people in every country, and there are people that do things right and do things wrong in every country, and there are honest mistakes and dishonest mistakes by people in every country. And USI-Tech is big and has many people in the company, and I'm willing to bet a lot of money that there are some double account registrations outside the U.S. Yet, this kind of being barred from making payments to prevent abuses is not going on anywhere other than in Canada and the United States. Possibly their response to that would be, well, the laws in Canada and the United States are the only places in the world where it's unlawful. They use the word barred from making any additional payments to prevent additional abuses. So abuse, they're not really even tying it to lawfulness, they're tying it to abuses, which I take that word to mean harms to the company and harms to other investors. But anyway, I'm sure I would be willing to bet that there are double account registrations and things outside the U.S. as well as there are some inside the U.S. Again, we'd like to point out that all misconduct worldwide with respect to misrepresentations or potential manipulation of our system will be punished with immediate expulsion from the company. So here they're saying worldwide we will expel people, but only in the United States and only in Canada has everyone summarily and entirely been barred from their accounts, whether or not you did anything wrong. And then we look forward to continuing our successful operations and continuing our success story. Best regards. So that's a communication that a lot of people have received recently. Earlier this week, that showed up. Then some other people are not getting that first message at all. And instead, they get this message. Due to unexpected increases in Bitcoin processing fees, we had sent some withdrawal transactions on December 5th and December 6th that have lower fees and will take some time to complete. All withdrawals made during that time will complete, but additional time may be required. You will receive all Bitcoin once the transactions have cleared the blockchain. So this is showing up simultaneous to the message that other people are getting within the United States that no payments can be made because they are investigating abuses related to double account registrations and other what they're calling fraud or misrepresentations. And yet other distributors within the United States and Canada are getting this message that simply says that on December 5th and 6th, we started some transactions that didn't have high enough fees and aren't going to go through. Interestingly enough, it was December 5th, exact same date there. The timing on that is very coincidental. It's the same time when the extraordinary announcement for termination of all accounts occurred. Same date, according to this notice, that fees were paid out at too low of a rate to complete transactions. Though this message says you will receive all Bitcoin once the transactions have cleared the blockchain. This is somewhat in opposition to the first message, which says nothing can be processed in the U.S. or in Canada because we are having to investigate any and all abuses by anybody and everybody, even if you specifically didn't do anything wrong. And so we can't do anything in the United States until that's complete and done. Then there is a third message, which is coming in the form of an email from the help desk or from the support team for people who have contacted the company and said, hey, why aren't my payouts coming through? And they're getting this explanation from the support team. Hello, thank you for reaching the USI-Tech support. Hope you have a great day. With regard to your concern, I would like to inform you that all accounts of US and Canada clients are blocked, and they must be blocked. The lawyers advised us to do this because they must see what they can do about the issue. So the Canada and the US clients cannot do anything with their account. They cannot withdraw, add money, buy packages, and they will not receive commission as their account is blocked. There is nothing a client can do at the moment until the lawyers check everything and let us know how we can activate the accounts. For further concern and clarification, please let us know. Thank you for contacting the support team. So first communication I went over says we're having to do this investigation because of misconduct, abuses, double account registrations, and we're locking everybody down. Well, what it says is we're not going to pay any amounts out. We're not going to make any payments. We are barred from making any payments while they do this and while they supposedly investigate this. This communication, which is showing up at the same time simultaneously for certain people, is saying simply, we sent out some transactions, the fees were too low, and you'll get your Bitcoin once it clears the blockchain. By the way Bitcoin is processed through the blockchain, all the miners prioritize processing transactions based on the highest paying transactions first. So if you set a transaction fee low enough for a miner, the processing fee low enough, it will never rise high enough in the queue. It will never rise high enough in the queue to ever get processed, because it's always going to be below other transactions which have higher processing fees that have been paid. And companies like Shapeshift.io and Coinbase.com, they always put pretty substantial fees, transaction fees, on their transactions because they want their clients happy, so they want their transactions to go through quick. So that's why the cost, for those of you that are experiencing that, that's why the cost is higher, and why transactions are slow is because certain services are putting really high fees on so that they make sure that their clients' stuff is going through fast. And so anything that has lower fees never gets a high enough priority. It never gets up high enough in the list to be the next transaction to be processed, because there's always a transaction above it that has higher fees attached to it to pay to the miners that process the blockchain transactions, to verify the blockchain transactions. And so it never gets processed. So it will never clear the blockchain if the fees are too low in comparison to how many miners there are and how many transactions can be processed per second or per minute, and what other people are paying in their fees. If there are enough transactions that have fees set too high, then lower fee transactions will never process, because that's how the blockchain for Bitcoin works. Prioritizes based on the fees that are being paid to the miners to process the transactions. Because of all of this, talking to people, hearing from people, lots of concern, lots of worry, lots of issues, as you all know, I just decided, you know what? Screw the rumor mill. We need to go to the horse's mouth, straight, drink from the trough itself and get information from the source. So yesterday, I made 3 or 4 phone calls to the Texas State Securities Board, left a message. They are very busy people, good people. I also was able to find the contact information, the email for the main the main enforcement attorney. You could call him a prosecutor, I suppose. My guess is that within their division, within their agency, they don't use the term prosecutor. He is the main attorney in the enforcement division within the Texas State Securities Board that is handling the USI-Tech matter, okay, for the Texas State Securities Board. I'm not going to give his name out for obvious reasons, but was able to leave a voicemail message and send an email. And today, January 10th, I had a phone call with that individual for approximately 45 minutes to an hour. Very informative phone call. So this is where we start to get into the breaking news. So the cease and desist order, so this is the information I've received. The cease and desist order is in effect from the time that the commissioner signs the cease and desist order. This is all pursuant to Texas state law, okay? Under the Texas laws with regard to securities. Once the commissioner of the Texas State Securities Board signs a cease and desist order, it's in effect from that moment. From that moment, the respondents, which are the two promoters in this case, and then USI-Tech as a company also, they are a respondent in the matter. Okay, here we have the Texas State Securities Board order, cease and desist order, filed by the Texas State Securities Board, signed by the commissioner, Travis Isles. Okay? So that is the cease and desist order. Once it is signed, it is in effect, it's in effect from the moment it's signed. The respondents, which includes USI-Tech Limited, right here, have 31 days to challenge the order or to request a hearing or to come into compliance with the order to the extent that coming into compliance is possible. Okay? So 31 days to respond. However, under Texas state law, respondents have the right and the ability to request and to have within 10 days an emergency hearing on an order like this. So this order was signed on December 20th, 2017. 10 days later, on December 30th, before the end of the year, and we are now sitting at January 10th, they could have had a hearing. They could have been heard in a court of law. There's been talk on the internet in the USI-Tech rumor mill and whatnot that USI-Tech can, will, whatever, challenge these things and will come out. They could have had a hearing within 10 days. My guess is, I don't know for certain, my guess is that such a hearing would not have fully and completely decided everything in the matter. It would have just been a kind of a preliminary hearing that determines, at least at that moment in time, to what extent the emergency cease and desist order remains in effect. Does it get altered by the judge? Does the judge, when he looks at it or she looks at it, say, well, I'll leave these provisions in place, but I'm going to change or alter these? I'm not saying that that's how it works. That's my guess of how it works. So the respondents have the ability within 10 days to have a hearing and have a judge another pair of eyes. So one of the comments that's been made, in the hopeful communications was part of, a comment made by the author right here, makes us all wonder about the abuse of power in our government, how one person representing one government organization can greatly affect the financial welfare of hundreds of thousands of families in a heartbeat. Well, USI-Tech could have not just left it to one person. I disagree that it's one person. I covered that in my previous video. But USI-Tech could have, within 10 days, had another pair of eyes look at this, and they could have fought it and done certain things. They could have requested, hey, judge, we've got all these promoters that signed up and whatnot. We thought we were acting in compliance and being reasonable and being good, and our intentions are good, and we're here before you. We showed up. We're here before you. That shows good faith, Your Honor. Could we please have the ability? We would like to have in the court order the court recognize our ability to simply pay people out, to pay out on, to put money into their daily available balance and to allow us, the company, to pay out withdrawals that are requested from USI-Tech promoters. I assume and believe that would be within the judge's power, because the only thing that is keeping USI-Tech from doing anything, transacting anything in the United States is this cease and desist order. There is no other formal action that I'm aware of currently that keeps them from doing anything. Furthermore, there's a legal doctrine that people have the right and ability to rely on what a judge tells them. If, in fact, a judge were to say, yes, that's fine, I believe that's okay, go ahead and continue to deposit money into people's daily available balance from what you represented was going to happen, the approximate 1% per day payout, go ahead and do that. Don't solicit any new business. Don't solicit any new customers in the United States. That part of the order still remains in effect. You're still barred for right now from soliciting or taking on any new customers or clients or anything. But go ahead and pay out the 1% because that's what you told people you would do. Go ahead and do that. And if people make requests for withdrawals from their account, go ahead and pay those out. Now, the government could alternatively argue, well, Judge, we need to seize those bank accounts, we need to freeze them so that we can look at them and see how the money has been moved around and how it's been used or how it's not been used. The SEC, an SEC authority could make such an argument. Don't know if they would, but bottom line here is USI-Tech could have gotten in front of another set of eyes and could have said, Your Honor, in good faith, we want to not hurt people. Can we pay out what we've told people we would pay out? There theoretically are other ways that this could have been handled too, but it seems to me that it would have been within a judge's power in such a hearing to do that. Not been done. Not been done. USI-Tech has not requested such a hearing. USI-Tech has not responded to the cease and desist order, which also, by the way, remains completely in force and effect as of today, as of now. Another big piece of news here is that the Texas State Securities Board has had zero communication with anyone or anything related to USI-Tech. So, no communication. No challenge to the order. No response. Now they have 31 days. They have 31 days to respond to the Texas State Securities Board cease and desist order. But there's been no response. There was no request for a hearing that they could have had within 10 days and no communication from USI-Tech. The cease and desist order is in effect until stated otherwise and until some other determination is made, either by a court or by the Texas State Securities Board itself. And when that happens, anytime that happens, when there's a change, the Texas State Securities Board puts out a public announcement. They make it public that there has been a change. So the rumor mill that is kind of churning, saying they're in the clear, all that kind of stuff, no, not from the Texas State Securities Board's perspective, at least. Also, in this conversation, higher authorities inside and outside the United States are communicating with that law enforcement agency about everything that's going on, everything that's happened, and are looking at doing other things. And that's all that was said. But authorities higher than and outside of the Texas State Securities Board, and inside and or outside the United States are looking at that. I was asked during this conversation if USI-Tech is currently paying out to its U.S. and Canadian promoters or investors, when requests for payments are made under the way things used to work, when it was all hunky-dory. When someone makes a requested withdrawal, is USI-Tech paying those? Obviously, the answer is no. I already covered the communications that various different people have been seeing. The answer to that is no, they're not paying out. In return, I asked the question, is it more, from their perspective, is it more legally problematic for USI-Tech to not pay U.S. and Canadian promoters? Well, they can only talk about U.S. promoters. Is it more legally problematic to not pay U.S. promoters, or is it more legally problematic to pay them? In other words, is there some legal problem with USI-Tech paying out to U.S., or in this case Texas, because we're talking about Texas, USI-Tech promoters? And the response I got was, really can't comment, or don't know that I have the ability to comment on that. So no comment on that. So I'm going to provide my analysis, or my opinion, what makes sense to me on this. Back to the cease and desist order. So as I said before, the only thing legally that is in force and effect, now there's always law and people can go talk to an attorney and ask an attorney, should I do this, should I not do that? If I do this, what caused me problems or not? If I do that, what caused me problems or not? And if an attorney says, yeah, I think if you do that, that'll cause some problems, a legal client can rely on that and can choose to not do that thing based on what an attorney says. But the only legally in force and effect thing, in other words, operation of a law enforcement agency of any kind that is affecting USI-Tech right now and its operations in the United States, is this cease and desist order out of Texas. And so, to me, that's the source you have to go to answer this question of what's more legally problematic for USI-Tech. Is it more legally problematic to pay or to not pay? Well, as far as this order goes, the problem or potential problem to the legal problem or potential legal problem to pay comes in the form of, would paying out constitute a violation of this order, constitute a violation of the cease and desist order? So you have to look at what was specifically ordered. What did the cease and desist order tell them they cannot do? So look at the order. Here are the orders. 4 things. It is therefore ordered that the respondents immediately cease and desist from offering for sale any security in Texas until the security is registered with the Securities Commissioner or is offered for sale pursuant to an exemption from registration under the Texas Securities Act. Number 1 talks about only talks about sales. We're not talking about sales. We're talking about paying people for money that's owed, not sales. Number 1, to me, in my opinion, doesn't seem to apply. Number 2, it is further ordered that respondents immediately cease and desist from acting as securities dealers or agents in Texas until respondents are registered with the Securities Commission, with the Securities Commissioner, or are acting pursuant to an exemption from registration under the Texas Securities Act. In my opinion, it's just my opinion, I don't think number 2 applies to paying out from someone's daily available balance if they make a request for withdrawal. Just my opinion. Paying out does not seem to me to constitute acting as a securities dealer or agent in Texas. Number 3, it is further ordered that respondent USI-Tech, USIT, immediately cease and desist from engaging in any fraud in connection with the offer for sale of any security in Texas. Well, I think there's an argument that could be made. I can't make that legal conclusion, only a court could. But I think there is a good legal argument that could be made that not paying people what they were promised to be paid constitutes a form of fraud in the securities world. You've got an investor, you've made certain representations about what they're going to get. And I know that in the past USI-Tech took the position that these aren't securities, these aren't investments. There are videos of certain people accidentally using the word investment, and then they actually on the video say, oh, I wasn't supposed to use the word investment, or I wasn't supposed to use the phrase return on investment. We're supposed to use different words, other words. But the Federal Securities and Exchange Commission has been clear. For example, you can go read the Dow token case. You can go to www.sec.gov. That's the Federal Securities and Exchange Commission for the United States. And you can go to their little search bar, and you can search their website for Dow token, DAO token. And that case came down in 2017, I believe, like July. And in that case, they very clearly stated that we don't care what words or phrases you use. You can call a return on investment, return on capital, you can call it whatever you want. You can call it roses, you can call it puppies. What matters is what's in the mind, what is the expectation that is in the mind of the investor or the person giving money related to the investment contract. If they have an expectation in their mind of a return on their money where the return is larger than what they gave you, and the return is being generated through the expertise of the person that the money is being given to, then that's an investment contract. And all investment contracts are securities. And the famous case that relates to that test, if memory serves correctly, is called the Howey case. I believe that's correct. I'd have to verify that. So number 3 here, actually, it seems to me, goes in favor of stating that USI-Tech should pay out, because there's an argument that could be made. I'm not making this conclusion, but there's an argument that could be made that it is a form of further fraud to not do what one told their investors that they would do, to not pay their investors what they told their investors that they would pay, to not put into effect the end result that was stated would occur for the investors. Now, has USI-Tech in its paperwork in the black and white and whatnot stated, this is an investment, investments are risky, you have a risk of loss? Yes, that's true. However, again, what matters is what was put into the mind of the investor. And there are all kinds of things out there, including YouTube video after YouTube video after YouTube video after YouTube video, of very clear, definitive statements being made about the actual risk that's involved, basically that there is no risk, and that the company is making money hand over fist, just tons and tons of money. The company is completely, totally, and utterly financially solvent, no worries, no concerns, and everybody will always and forever get paid every dime under the compensation plan, including commissions, including daily payouts from BTC packs invested. So number 3, to me, they're ordered to cease and desist any and all fraud in connection with the offer for sale of any security in Texas. Number 4, it is further ordered that respondents immediately cease and desist from offering securities in Texas through an offer containing a statement that is materially misleading or otherwise likely to deceive the public. Again, number 4, in my mind, is not relevant to this question. It doesn't help answer the question of, is it more legally problematic to pay USI-Tech promoters their withdrawals that they have requested from their daily available balance or not? All number 4 simply says is stop offering securities for sale in Texas where that sale contains any statements that would mislead the public. So in my mind, number 3 is really the only one, my opinion, number 3 is the only one that seems to be really on point in answering that question, and it seems like there would be a very good argument to make that number 3 goes in favor of people being paid. So finally, to wrap this up, I had a conversation with this attorney in the enforcement division at the Texas State Securities Board about what is the legal process moving forward. How does this all work now? So under Texas state law, we have this cease and desist order. You've told me that the cease and desist order continues to remain in effect. There's been no challenge to it. It is still in effect. There's been no change on that. So what happens next? What's the process that happens here? I asked him, does it automatically at some point in time move into formal criminal indictment or charges being filed in some venue? And what he stated was that cease and desist orders are like this are used in emergency situations. It's a tool to be able to get engagement and involvement from the respondents and communication, as well as to put into effect immediate relief for people that they fear are or might be or may be put in harm's way, so kind of emergency situations, and to get some de minimis immediate relief in emergency situations, and then trying to get the respondents to engage. I would add, this is my own personal note. This is not something that the individual at the Texas State Securities Board stated, but in order to file a cease and desist order like this, there has to be some kind of preliminary determination under Texas state law, which governs that agency, that enables the emergency cease and desist order to be put into effect. There is in other words, what I'm saying is there is a legal standard that is applied that the commissioner has to look at and has to ask, okay, are the legal conditions and requirements met for me to be able to sign this emergency, or it's not titled as an emergency, but this cease and desist order. And they put out the cease and desist order, so the answer to that question is yes, the determination was made, the preliminary determination was made to that those requirements were met, and therefore were able to, and they did, put out the cease and desist order. After that, the individual at the Texas State Securities Board stated that the agency continues its enforcement investigation, continues to investigate. It seems to me from the conversation, though details were not discussed, that is continuing on. And then when and if a crime is found, so we're now in the criminal realm, and we're talking about probable cause for charges to be able to be filed for believed violations of law, of criminal law. When and if a crime is believed to have been found, then formal criminal action is taken. Formal criminal charges are filed if, big if here, if it makes sense to continue on in that jurisdiction, for those criminal things to be handled in that jurisdiction. Well, then the last part of this conversation that I had is very, very interesting. The feds and other state SECs, now they call themselves by different names, but the federal SEC and other state SECs all communicate. This is not me telling you this. This is part of the conversation that I had. I have said this in the past. I think I said it in my first video. But the feds and other state SECs, they communicate and they coordinate, and that's legal, and they decide, how to proceed. So again, as the investigation continues, the process is if and when they find or believe that they have found criminal behavior, then formal criminal charges are filed if it makes sense to continue in that jurisdiction. And if it doesn't make sense to continue in that jurisdiction, then the matter ends up being handled in another jurisdiction after there's been communication and coordination elsewhere with other agencies. It's also my belief, this was not specifically discussed, it's also my belief that kind of thing can and probably would, or certainly could, happen prior to even an emergency cease and desist order being issued. Long story short, we've got, there have been indications here that not only is the cease and desist order in place still, USI-Tech is not in the clear. There's nothing. I have no indication from the horse's mouth from Texas State that anything is in the clear, that there's been any change at all in the matter from the Texas State Securities Board's standpoint. That there's been no change in that status, and that furthermore, there actually it sounds like there are other things on the horizon. Don't have any details. Not representing I have any details. Don't know the nature or extent of that, but it sounds like there is something. So that's the breaking news. The rumor mill can maybe now somewhat be put in its place, and people can have some actual information. about what is real and what is actual and what is true. Long story short, things are relatively the same as they were on December 20th when the Texas Securities Board put out its emergency cease and desist. And there may or may not be future things coming down the pike from whatever places, whatever jurisdictions. And again, I don't know that. Okay, well, I think that about wraps it up here. Again, my name is Josh. I'm here with USI-Tech LegalClaims.com, here to help all y'all, as Texans would say, with these issues with regard to USI-Tech. We understand the difficulties that you're facing, and we're sorry for those. If you think that we can help you, please contact us. I'm supposed to say like and subscribe, I guess. I'm not a YouTuber, but unintentionally, I guess I'm becoming one. But please contact us if you think that we can help you, or just stay tuned here for more information, and hope for the best for all of you. I'm not your attorney, but maybe I should be. Have a great day.